You're in an automobile crash. There's always insurance issues that arise immediately. You're usually talking to an insurance adjuster of your company or the guy who hits his company right away. I'm Gary Berger of the Berger Law Firm, and I'd like to talk to you a little bit about these insurance issues because they can be very confusing. First of all, you have your own insurance that you purchased. Under that insurance, you have different coverages. For instance, you have coverage for your car damage or your property damage. So your insurance can pay your property damage. You also have a med pay provision, typically, that provides you some medical payment coverage that'll cover your medical bills. Some insurance policies say that they just cover straight your medical bills. You toss the medical bills in, they'll pay you. Others say that they will only pay your medical after it's been submitted to insurance. So sometimes you have to submit it to your own health insurance, and then they will pay the excess or the co-pays or the deductibles for the year and pay you that way. Typically, lawyers don't charge for MedPay recovery until they have to fight for it. So another provision that you have in your insurance is uninsured and underinsured coverage. Uninsured coverage comes into play if the person who hit you, the person whose negligence it was that caused your injuries, has no insurance whatsoever. Then you have an uninsured claim against your own insurance company. The minimum policies in both Missouri and Illinois for uninsured coverage is $25,000. So if you're injured and the person who rear-ended you or was driving the motorcycle that hurt you doesn't have insurance, you go after your own insurance coverage for all the personal injury damages and bodily injury damages that you would have. What are those damages? For any case, regardless of whether you're going against the other side's insurance or yours, your damages include your medical expenses, your wage loss damages, your pain and suffering, and any future pain and suffering, wage loss, and medical expenses you have. There also are components of damages for disability or disfigurement if you have a scar. Disability is like if you have a limp, and those are mild examples. They can go all the way to being in a wheelchair for the rest of your life. So those are the typical insurance policies that you have on your own policy. If you rent a car, and in some other policies, you also have something called PIP insurance or personal injury protection insurance that is often sold you. So that's this very similar. So if you're injured, you have PIP insurance, you can go after that policy for the injuries that you suffered because it's supposed to protect you from that personal injury protection. Now, what about the other side, the person who rear-ended you or the person whose fault it was that you were injured? That person hopefully does have insurance. If that person has insurance, then let's talk about that. So very rarely will they have medical payment coverage. They will not typically have that type of coverage. What they will have, though, is liability coverage. So if they are liable and for whatever damages they are liable to you, they should pay that amount. The minimum coverage in Missouri and Illinois is $25,000 for that. So you make a claim against the other side's insurance policy for your damages. Again, wage loss, medical, pain and suffering, emotional distress, disability, and disfigurement. You maintain that claim against them. If you have a small injury, you're rear-ended, you go to your primary care doctor, that's all the medical you get, you probably do not need a lawyer. Call up the defendant's insurance claim representative, send them your medical bills, send them the day you miss from work, add $500 or $1,000 to it for pain and suffering, and settle that claim. Now, that's with the caveat that you do not want to ever settle your case and then have more medical and need a surgery the day later. So please make sure you're at your maximum medical improvement. Do not settle a case until you know all the injuries and damages that you've sustained from this incident. So you have a claim against the other side's insurance company under their insurance policy, and you contact them and you contact their agent. That's the information you get when you're at the side of the road and you ask for their insurance card. They may have other provisions too. It's possible they have MedPay. You should inquire. And you should make sure that you get all of their insurance too when you're investigating that. Now, if you're at the point where you're worried about over $25,000 in coverage, $50,000, $100,000, that's the time when you probably need a lawyer, because a lawyer typically does not add value to a claim where there's little or no injury, little or no impact. There's no medical care. a lawyer's not going to add a lot of value to that claim. But a lawyer like me, and that's what I've done for 25 years and represented thousands of people, I fight these insurance companies all the time and fight for coverage. So the interesting things becomes when you need to see if there is additional coverage. Is it a $100,000 policy, or is it really only $25,000? Is there a lot more insurance at issue in the case? Is there homeowners? Is there excess coverage? We've had cases where we have found an extra $500,000 or $1 million in coverage for an automobile accident that we did not know was there. So let's say, though, that your injuries are $100,000 or $200,000 in value, but the defendant only has $25,000 in coverage. Well, that's where your underinsured coverage comes into play. Underinsured coverage means when the defendant who's liable and who injured you is underinsured, does not have enough insurance to cover all of your damages, then you have a claim against your own policy under the underinsured provision of that policy. A typical number is $50,000 or $100,000 in underinsured coverage. So, if the defendant has $25,000 in coverage and you have $100,000 underinsured policy, then you would go after your own policy for typically $75,000, because most underinsured policies have a set-off provision that says that the amount that you recover from the tortfeasor, the person who was negligent and injured you, that gets set off against the amount of the coverage. It's kind of a bogus exclusion or limitation, but that's what it is. So you would pursue that claim. It's very important that first you have to exhaust the underlying coverage, or the coverage of the person who hit you, before you could make your underinsured claim. So that's the long and the short of the different insurances. Uninsured is very complicated, because if you have an uninsured claim, meaning the defendant was not insured at all, then in Missouri, you can stack that coverage, meaning if you have 3 vehicles, instead of having only $25,000 in coverage, you'd have $75,000 or 3 times $25,000. There are also differences in Illinois and Missouri about how those claims are made. And uninsured and underinsured coverages in Illinois are subject to mandatory arbitration, so that if the insurance company put a arbitration provision in the policy, you can't go file suit in it. You have to file an arbitration claim. But you kind of go to trial quicker. The insurance can get also more confusing because of a couple other issues. One is that if the insurance company refuses to pay or treats you fairly, you have a bad faith claim, or you have the potential to have a bad faith refusal to settle claim with that insurance policy, or a vexatious refusal to settle claim. I've handled many of those claims as well. Another issue is, what about if there's multiple insurance policies? What if there's a homeowners and other policies? And then the question is does that policy stack, or is that concurrent? And those are issues we fight. Sometimes insurance companies are going to try to exclude coverage for different reasons, and that's a whole nother area too. For instance, typical exclusions on an auto policy are if you're driving an ATV or an off-road vehicle or a golf cart, or if a vehicle is stolen, or if you intentionally hit someone. Those are going to be exclusions under the policy. Also, sometimes policies and claims are denied because you don't pay the premiums anymore. But there's pretty good law in Missouri that if you later pay the premium, it's retroactively reinstated up until the time as if there's no gap in coverage, so that you get the full coverage. So if you get in an accident and you miss an insurance payment, make sure you pay that insurance. The question often comes up about, what do you do with health insurance? And really, the general rule of thumb is, if you have health insurance and you get injured, use your health insurance for your medical care. Many hospitals will try to get you to not to, because they make more money from the med pay and other sources, because health insurance has general contracts with them where they negotiate down the reimbursement rate to 50, 40, 30%. But if you have health insurance, regardless of how you're injured, use it when you go get your health care. Use all your health insurance. It is true that then what your health insurance will do is they will subrogate, or they will make a claim against the personal injury case to get money paid out. But it's much better to go that route, because let's say your medical insurance pays you pays 40 cents on the dollar to your providers, that's a reduction, so you only have to pay them 40% back. And then what we do very aggressively at Berger Law is not only do we get as much money to settle or in a judgment in the case in the first instance against the defendant, we make sure when we negotiate paying back the health insurance company that we get them to reduce it. So typically we'll get a third reduction, 25%, maybe up to 50%. And we do that very aggressively because we want to put as much money in the pocket of our clients, which is tax-free, by the way. Personal injury settlements are tax-free. And whenever a health insurance company has a claim in the case, it's called a lien or a subrogation interest. So that's just a terminology you may hear. Other providers can also provide liens. For instance, some providers will treat you, if you don't have health insurance, on a lien basis, meaning that they'll get paid out of the case. And that's very good. That really helps a lot of injured people. There's also other types of liens as well, such as work comp. So if you're in an auto accident but you were working at the time, you will have workers' compensation insurance benefits that will pay you. They'll pay you 2/3 of your weekly wages while you're off work. They'll pay you all your medical, and they'll pay you a lump sum disability settlement at the end of the case. But they will also request a reimbursement from the civil case when you sue on the auto or the truck or the slip and fall, which injured you in the first place. In those cases, those liens are reduced pursuant to Section 287.150 of the Missouri statutes, or called the Rudiger formula. We work to maximize and lessen those liens as much as we can as well to make sure we get as much money in your pocket. Sometimes MedPay wants to get their money back as a lien in your case as well. So it's important to know all the liens in the case, and when the client leaves the case, you don't have anybody coming after you for money. There's also a lien reduction statute in both Missouri and Illinois that if the recovery is low for whatever reason, for instance, liability was tough, and that you may be liable, so you're going to take less to settle the case than you would otherwise. Or maybe some of the medical care is more attenuated. Maybe you had knee replacement or hip replacement surgery 3 years after the accident, and it may not be connected to the incident because it may be also partially because of degenerative changes in your body, then you may take less to settle a case. Well, when that happens, and it has happened to some of my clients, we use the lien reduction statute aggressively to make sure that those liens are reduced. And the way the lien reduction statute is used is after the attorney's fees and expenses, the clients gets half the money, and then the other half of the money is split among the lien holders on a pro rata basis. I know I was talking fast, and I know I went over a lot of insurance topics in this short video, but there's a lot of insurance issues that are out there. I lectured about these insurance issues to other lawyers and to clients all the time. We navigate these, we read these insurance policies, which is boring, but that's where the rubber meets the road, and recovering from insurance companies, and making sure that the liens are addressed properly, and making sure there is no stone left unturned in finding additional insurance coverage. Because if someone has a lot of damages, we are artful and adept at finding other insurance companies and finding other policies and finding other defendants who are liable to make sure that our clients are 100% compensated for their injuries. If you have any other questions about insurance coverage, they're written about on this website. You can call me, Gary Berger, at 314-542-2222. You can email me at gary@bergerlaw.com. Get a hold of me on Facebook or Google us or however you want. Thank you very much.